In a significant development for X and its owner Elon Musk, the Australian Federal Court has overturned the prohibition on the social media platform from hosting the video depicting the stabbing of Sydney Bishop Mamari Emmanuel. The incident, which took place at Christ the Good Shepherd Church in Wakeley on April 15, was captured during a live-streamed service. Following the event, X was directed by Julie Inman Grant, the Australian eSafety Commissioner, to delete 65 tweets showing footage of the attack, labeling the videos as Class 1 under the Australian classification law, which identifies content featuring explicit or offensive violence with significant impact or detail. X adhered to this directive by implementing geo-blocking for the content in Australia, though Australian users accessing the site via VPNs remained able to view the attack. X, however, declined to remove the footage entirely from its platform. This led to significant controversy and subsequent legal action when the Australian authorities sought to enforce a global takedown of the footage, affecting viewers worldwide. On Friday, Tim Begbie, King's Counsel representing the eSafety Commissioner, described to the court how the online material graphically and shockingly depicted the attacker repeatedly and violently stabbing the bishop, as reported by The Australian. In contrast, Barrister Brett Walker, Senior Counsel, representing X and backed by the law firm Ashurst, expressed concern over the mandate requiring X to eliminate the content globally as the only feasible method to comply with the takedown order. During the brief hearing on Monday morning, Federal Court Justice Jeff Kennett declined to extend the preliminary injunction initially granted on April 22, 2024, and subsequently extended on April 24. He also reserved judgment for costs on the application. The case has attracted global attention, particularly in the US, where free speech advocates sought to participate, supporting X's stance. Last week, the Foundation for Individual Rights and Free Expression and the Electronic Frontier Foundation petitioned the Australian Federal Court for permission to intervene. The matter also resonated politically, with opposition leader Peter Dutton last month voicing a position similar to that of X. "I'd love to say that it could be taken down so that no kid across the world could watch it, and we strongly support the Commissioner's position in relation to taking it down so that Australians can't view it," he remarked. "But we can't pretend that Australia can dictate to other countries around the world what people see within their boundaries. As we wouldn't tolerate that here, that Russia could dictate what content could be seen in Australia." Remarkably, the federal court decided that it would side with X, and on Monday handed down its judgment, basically giving the eSafety Commissioner a spank on the butt. So what we're going to look at today is the statement put out by the eSafety Commissioner, as short as it was, and then we're going to go directly through the judgment to find what Justice Kennett's reasoning was. Politicians like Craig Kelly have already made comments showing that it is a tongue lashing that the eSafety Commissioner had well deserved. So let's get stuck into it, people. Okay, so the reasoning. Federal Court of Australia, the eSafety Commissioner versus X Corp, Federal Court of Australia 499. Skip over the regular bump, which is just the tram tracks and various bits and pieces. So the court has ordered that the application to extend the interlocutory injunction granted on 22 April 2024 is refused. We should be very clear. The preliminary hearings are still ongoing. This was a temporary injunction that was put in place by the federal court in order to ensure that X was at least ordered to take down the videos worldwide, much to my disgust, because as far as I'm concerned, nobody, in particular Julian and Grant of the eSafety Commissioner, has the right to tell anybody outside the boundaries of Australia exactly what they can and cannot view. So, per Justice Kennett, on 16 April 2024, the applicant, being the Commissioner, issued a notice, the removal notice, to the respondent X Corp under Section 109 of the Online Safety Act 2021. Under Section 111 of the Online Safety Act, a person must comply with a requirement under the removal notice to the extent that a person is capable of doing so. Section 111 specifies a civil penalty of 500 penalty units, and thus is a civil penalty provision within the meaning of Section 79(2) of the Regulatory Powers Standard Provisions Act 2014. Basically, what that boils down to is that failure to comply with Section 109 of the Online Safety Act means you get one heck of a butthurt of a fine. Section 162 of the Online Safety Act provides that a civil penalty provision is enforceable under Part 4 of the Act. Section 82 of the RP Act provides for an authorised person to apply to a relevant court for an order that a person who is alleged to have contravened a civil penalty provision is to pay a pecuniary penalty. Section 121 of the of the Regulatory Powers Act, provides as follows. If a person has engaged in, is engaging, or is proposing to engage in conduct in contravention of a provision enforceable under this part, a relevant court may, on application by the authorised person, grant an injunction, restraining the person from engaging in the conduct, and if in the court's opinion it is desirable to do so, requiring the person to do a thing. Yes, it's nice and vague as to what a thing is. The court has very wide discretion in that regard. If a person has refused or failed, or is refusing or failing, or is proposing to refuse or fail to do a thing, and the refusal or failure was, is, or would be in contravention of a provision under this part, the court may, on application by an authorised person, grant an injunction requiring the person to do that thing. Basically, this is the enabling provision in which the eSafety Commissioner went to the federal court and applied for an injunction to force X to take down the videos of the bishop being stabbed. The Commissioner, who alleges that X Corp has not complied with the notice, seeks a declaration to the effect that, together with a pecuniary penalty under Section 82 and an injunction under Section 121, subsection 2, the proposed injunction is designed in substance to require X Corp to do that which on the Commissioner's case, the removal notice requires. An application by the Commissioner for an urgent interim injunction came before me as a duty judge on April 22, 2024. Section 122 of the RP Act confers an express power to make such an injunction. Although counsel appearing by video link announced an appearance for X Corp, he had no formal instructions and had only just received the material. The hearing therefore proceeded on the basis that the Commissioner was applying for the interlocutory injunction ex parte, basically without X being present. I didn't specifically agree with this taking place. It was very disappointing to see that this even went forward, given that it had taken some time for X to appropriately brief counsel. It's basically like having a file handed to you the day of and saying, here, run this case. That's never going to work well for anybody. The fact that the court took it ex parte speaks volumes about how they expected to rule. I granted an injunction effective until 5 p.m. on 24 April 2024 and listed the matter for a further hearing on that day. On April 24, both parties were represented. However, counsel for X Corp informed me that his client needed more time to assemble evidence and provide instructions on the question of interlocutory relief. I extended the injunction to 5 p.m. on 10 May 2024 and listed the matter for a further hearing that day. At the close of arguments on 10 May, I extended the injunction until 5 p.m. Monday, 13 May 2024, so that I could consider my decision over the weekend. On the morning of 13 May 2024, I made an order refusing the Commissioner's application for a further extension of the interim injunction. These reasons explain why I concluded that the injunction should not be extended further. I also set out below my reasons for suppression orders that I made during the hearing on 10 May 2024. Now, as I said, this is an interim injunction. The case itself still is needed to be heard in full. The fact that His Honour has taken the step of refusing the injunction, what he's basically saying is that on the balance of convenience, our civil standard, so who is more likely to be inconvenienced, it is unreasonable to require X to attempt to try and take down 65 different URLs across the planet. On the evening of 15 April 2024, Bishop Emmanuel, was attacked and repeatedly stabbed by a lone assailant while giving a sermon at the Assyrian Christ the Good Shepherd Church in Wakeley, New South Wales. A short video of the attack exists, the stabbing video. The video runs for about 11 seconds and has been shown on most forms of media, including mainstream television news. It shows from a vantage point apparently near the back of the church, the lone assailant rushing at Bishop Emmanuel and attacking him. The assailant raises their right arm and strikes the bishop several times with a downward motion. The bishop falls backwards. It is not clear from the video that a knife is being used. It is not clear from the video that a knife is being used, although that can be inferred from the motions of the assailant. The shocked and distressed reactions of the witnesses can be heard. The Commissioner's office became aware of social media posts containing the stabbing video. They reached the view that the video was of such a nature that it should be subject to the removal notice under Section 101. The Commissioner's officers became aware of the social media posts containing the stabbing video. They reached the view that the video was such of a nature that it should be subject to a removal notice under Section 109 and approached major online service providers. Some providers removed URLs containing the stabbing video from their platforms altogether. X Corp did not. The removal notice was issued by a delegate of the Commissioner, the delegate, on 16 April 2024. Relevantly for the purposes, the notice says this removal notice is given to you under Section 109 of the Act and requires you to take all reasonable steps to ensure the removal of the Class 1 material specified in Attachment A. Boiling that down, what they're saying is that the government has the right to determine what is Class 1 material and should therefore be barred from viewing by Australians. Personally, the Ministry's truth-style censorship really irritates me. The fact that we are leaning towards that, the fact that the eSafety Commission even exists, is problematic. Attachment A identifies the relevant material by way of a list of 65 specified URLs, each of which designates a post on X Corp's social media platform X. There follows a description of material, which consists of a description of the contents of the stabbing video, followed by the statement, "The content is Class 1 material under the Online Safety Act 2021 for depicting matters of crime, cruelty, and real violence in such a way that it offends against the standards of morality, decency, and propriety generally accepted by reasonable adults to the extent that it would likely be classified RC." The references in the removal notice to Class 1 material and taking all reasonable steps to ensure removal come from Section 109 of the Online Safety Act. At this point, in order to identify the basis and effective removal notice, it is useful to set out the relevant parts of Section 109. If material is or has been provided on a social media service, and the Commissioner is satisfied that the material is or was Class 1 material, and the material can be accessed by end users in Australia, and the service is not an exempt parliamentary content service, is not an exempt court or tribunal content service, or an exempt official inquiry content service, the Commissioner may give the provider of the service a written notice to be known as a removal notice, requiring the provider to take all reasonable steps to ensure the removal of the material from the service, and to do so within 24 hours after the notice was given to the provider, or such longer period as the Commissioner allows. Let's be very clear here. The Online Safety Act, as you can tell, carves out a nice little exception clause for anything that's government related in order to provide that things posted by politicians or government departments are exempt. I don't think that's appropriate. So far as it is reasonably practicable, the material must be identified in the removal notice in a way that is sufficient to enable the provider of the service to comply with the notice. Class 1 material is defined by Section 106. The only relevant aspect of the definition is 106(1)(b), which is as follows. Material where the following conditions are satisfied. The material is a film or the contents of a film. The film has not been classified by the Classification Board under the Classifications, Publications, Film and Computer Games Act 1995. And if the film were to be classified by the classification boards under the Act, the film would likely receive a classified RC rating, which is basically our rating above R18+. I believe the only one above RC is actually not classifiable, like NC. Another important expression in Section 109 is that is affected by the definition of the Online Safety Act is removal. The cognate expression removed is defined in Section 12 as follows. For the purpose of the Act, material is removed from the social media service, relevant electronic service, or designated internet service if the material is neither accessible to nor delivered to any end users in Australia using the service. Setting aside the fact that probably allows for a certain level of leeway with VPNs anyway, as noted above, Section 111 requires a person to comply with the requirement under removal notice to the extent that the person is capable of doing so. How that qualification interacts with Section 109(1)(e), pursuant to which the notice only requires all reasonable steps, may need to be explored at some stage, but that is not the subject of the argument on this occasion. The final injunction that the Commissioner seeks aligns, as noted above, with the Commissioner's conception of the word of what removal notice required X Corp to do. It was framed in several alternative forms in the originating application, on the basis that the optimal form would depend on the fuller understanding of how X Corp systems work at a technical level. The prayer for relief is as follows. In order under Section 121(2) of the Regulatory Power Standard Provisions Acts, requiring the respondent to do the following. Remove in the ordinary sense of the word, rather than the meaning of Section 12 of the Online Safety Act, the material identified in the notice from the respondent's X service previously known as Twitter. Alternatively, restrict the discoverability of the material identified in the notice to the author's profile so that only the author and no other end user can view the material. Alternatively, hide the material identified in the notice behind a notice that such X user can only see the notice, not the material identified in the notice, and cannot remove the notice to reveal the material. Or alternatively, restrict the discoverability of the material to prevent the material identified in the notice from appearing in any search results in any X feed or on the X service. Now you'll note none of those four alternatives specifically relate to end users in Australia. It just specifically says end users. So this is where the relief was specifically requesting X to have an injunction against them, forcing them to remove the tweets globally. As for how they would actually be able to do certain things, I can understand why they said that they did alternatives based on how Twitter or X actually run their platform, because restricting the discoverability may have been simpler. It may well have been... Basically, they just didn't want to get caught up on a technicality. The interim injunction granted on 22 April and extended to 24 April was in the following terms. There'd be an interim injunction under section 122(1)(b) of the RP Act, requiring the respondent as soon as reasonably practicable and no later than within 24 hours to hide the material identified in the notice behind such notice, that an X user can only see the notice, not the material identified in the notice, and cannot remove the notice to remove the material. They shouldn't have been... That was a step too far as it was. The reference to hiding the material behind the notice was suggested by the Commissioner by reference to an online policy document published by X Corp to its users, which describes X Corp's processes in relation to material posted on its platform that X Corp considers unsuitable. Consideration of the interlocutory injunctions usually proceeds by reference to two issues: whether there is a real issue to be tried, sometimes put as to whether the applicant has a prima facie case for which the relief is sought, and where the balance of convenience lies. The party's argument in this case proceeded in that way, and my reasons will also. The fact that both the injunctions sought by way of final relief and the interlocutory judgment are statutory, rather than granted as an exercise of equitable jurisdiction, does not change the issues in any fundamental way. A real issue to be tried is at least ordinarily a sine qua non for a grant of an interlocutory injunction, but does not, for the reason, necessarily resolve into a binary yes or no question. That is because the two issues are not always independent of each other. The nature of the injunctive relief and the burden that it will place on the respondent can make it appropriate to consider as part of the balance of convenience the strength of the prima facie case that is presented. So basically, the court has to weigh up whether or not the argument that the eSafety Commission has against X is stronger than the inconvenience that would be caused to X by having to engage in hiding stuff behind notices or by removing it entirely. Although the power invoked to support the interim injunction in this case is statutory, it remains necessary to identify the prayers or prayer for final relief in support of which it is sought. There must be a real issue to be tried, or a prima facie case thereof, in support of some form of final relief to which the interim injunction is connected. Here, the proposed interim injunction connects to the proposed final injunction that would require compliance with the requirements of the removal notice as interpreted by the Commissioner. Although being mandatory in form and effect, it does not so connect by preserving the status quo pending a final hearing. For the interim injunction to be continued, the Commissioner must show that she has a prima facie case for the final injunction that she seeks. So much was not controversial. The two issues were agitated in this connection: whether the removal notice was a valid exercise of power under Section 109, and whether, given that the notice only requires and can only require X to take reasonable steps to ensure removal of material, the proposed final injunction goes further than what is required for compliance with the notice. Section 109 of the Online Safety Act, which is the source of power for the removal notice, has been set out above. If the notice was not authorized by Section 109, it is of no legal effect and cannot form the basis for the grant of the injunction under Section 121. X Corp argues that, therefore, the issue of the valid removal notice is part of what the Commissioner must prove at the final hearing. The Commissioner has led no evidence at this interlocutory stage for the validity of the removal notice other than the notice itself. Such evidence has been adduced by X Corp concerning the delegate's reasons for issuing the notice indicates, according to X Corp, that the Commissioner probably will not be able to establish the validity of the notice. That evidence will be considered shortly. The argument that the Commissioner must prove the validity of the notice at the final hearing cannot be accepted at its highest. In Osley versus the Queen in 1997, The more appropriate principle that the validity of an administration act or decision and the legality of steps taken pursuant to it are presumed valid until the act or decision are set aside in appropriate proceedings. Where acts are of an official nature, everything is presumed to be rightly and duly performed until the contrary is shown. Owsley was the case where listening device warrants were asserted to be invalid as a basis for objecting to the tender of evidence obtained under those warrants. In other words, it involved a collateral attack on the warrants rather than an administrative law proceeding seeking to have them set aside. The decision in Owsley predated Minister for Immigration and Multicultural Affairs v. Bardwaj in 2002, and the reference by Justice Gummow to a presumption of validity needs to be read in light of what was decided in that case. In that case, Justice Hayne said, administrative acts and decisions are subject to the challenge in proceedings where the validity of the act or decision is merely an incident in deciding other issues. If there is no challenge to the validity of the administration act or decision, whether directly or by proceedings for judicial review or collaterally in some other proceeding in which its validity is raised incidentally, the act or decision may be presumed to be valid. But again, that is a presumption which operates chiefly in circumstances where there is no challenge to the legal effect of what has been done. Where there is a challenge, the presumption may only serve to identify and emphasize the need for proof of some invalidating feature before a conclusion of invalidity may be reached. Many kinds of litigation would become very unwieldy if a party relying on the legal effect of an administrative decision could be put to proof of all factual matters going into its validity. Where an official notice, such as the removal notice here, is relied upon and is valid on its face, the starting point at least must be that it has the effects that it purports to have, unless there is some invalidating feature that is proved. Even if that is not correct, and the Commissioner must prove the validity of the removal notice at the hearing, it would, in my view, be incumbent on X to at least identify clearly any basis asserted for invalidity. For the purpose of identifying the real issue to be tried at an interlocutory stage, it is appropriate to proceed on the basis that the removal notice is valid unless the evidence discloses a substantial basis for doubting that it has validity that will be established at trial. These observations have some relevance to how the evidence, such as it is, going to the delegates' reasoning process is to be understood. That's a very long-winded and verbose way of saying they've issued the notice. The court has to take it on face value that the notice has the power to do what it says it does and that it was validly issued. Until such time as it goes to trial and it is challenged, we have to take it at face value that the notice is what it says it does. On 30th of April 2024, the solicitors for X Corp wrote to the Commissioner's solicitors requesting a statement of reasons under Section 13. No, let me start that again. On 30th of April 2024, the solicitors for X Corp wrote to the Commissioner's solicitors requesting a statement of reasons under Section 13 of the Administrative Decisions Judicial Review Act and Section 28 of the Administrative Appeals Tribunal Act for the decision to issue the notice. The statement was requested as a matter of urgency, although the legislation relied upon allows the decision maker a period of 28 days after a request for the provision of reasons. The Commissioner's solicitors responded to the effect that a statement of reasons had not been but would be prepared. Noting the timing of these proceedings, they enclosed a document signed by the delegate dated 16 April 2024 and entitled Statement of Reasons. They noted that this document, which I'll refer to neutrally as the decision record, had not been prepared for the purposes of or in accordance with either of the acts. The decision record would likely be found not to comply with the requirements for a statement of reasons under either act. However, that is currently not to the point. The Commissioner's solicitors were presumably writing on instructions, and I am therefore prepared for present purposes to proceed on the basis that the author of the decision record did not intend for it to be a document that could be furnished in satisfaction of the duty to give reasons under those acts. However, that also does not take matters very far. The document is signed by the delegate and purports to record her reasons for the decision. It is thus the only evidence so far of her reasoning process. The decision record has the following relevant features. It says expressly that it sets out the delegate's reasons for deciding to give the renewal notice. Willing to bet that's a typo. To give the removal notice to X Corp. It briefly sketches the legislative framework and annexes the relevant sections of the Act to the appendix. Those sections are 106 and 109. Under the heading Material relied upon to make the decision record, it says, I have taken the following information into account in making my decision. On 15 April 2024, the eSafety Commissioner received 4 complaints about violence and violence extremism on the platform known as X and Twitter.com. Complaints about violence are listed. Complaint about extremism is listed. The content investigated in the complaints, the material is described in Appendix B and was found to depict matters of crime, cruelty, or violence at the following URLs, which have been redacted. The material can be accessed by end users in Australia. eSafety investigators identified further instances of the same material being accessed at different URLs on X. The URLs to the material, including the URLs identified by the eSafety investigators, have been included at Appendix B. On 16 April 2024, an informal removal request for all of the URLs included at Appendix B was sent to X via their legal request reporting portal. Oh, look, now we know their legal request reporting portal. The following ticket numbers were provided, but no further response was received. The material is still available at the time of giving the notice. On 16 April 2024, the incident was described by the New South Wales Premier, Chris Minns, as an act of terrorism, and the New South Wales Police Commissioner, Karen Webb, declared the incident a terrorist act. Interesting how they actually finally got around to that. Reference is then made to documents taken into account. These were the offending material, 2 policy documents issued by the Commissioner, and relevant sections of the Online Safety Act. Under the heading Reasons for the decision record says, I'm satisfied that the requirements for giving a removal notice under Section 109 have been met. Having considered the above documents and information, I am satisfied that the material is Class 1 material as defined by Section 106B of the Act, because the material is a film or the contents of the film. The film has not been classified by the Classification Board, and if the film were to be classified, the film would likely be classified RC, refused classification, by the Classification Board as it depicts matters of crime, cruelty, and violence in such a way that it offends against the standards of morality, decency, and propriety generally accepted by reasonable adults, to the extent that it would likely be classified as refused classification. The material is provided on X, which is a social media service as defined under Section 13 of the Act, because it's an electronic service that has a sole primary purpose of enabling online social interaction between 2 or more end users. The service allows end users to link to, interact with some or all of the other end users, and the service allows end users to post material on the service. X Corp is the provider of the social media service X. The material is not provided on an exempt service as defined in Section 5 of the Act. The material can be accessed by end users in Australia. The decision record also says, in addition, I've considered the following. On 15 April 2024, X Corp were notified by email at Karen at x.com of the material being accessed on X. A representative from X Corp replied advising that their teams were across the situation and for the eSafety to report the material using the legal requests form. I pause here to note that while the decision record would be admissible on final hearing as evidence of the delegate's thought process, the same might not be true of a statement of reasons prepared in the shadow of this litigation under the either of the AAT or the ADJR Acts. If the Commissioner sees a need to prove further facts concerning the delegate's reasons, it may be necessary for that be done by way of an affidavit. The view which I take as to what the onus of proof lies in relation to the validity of the notice means that the decision record supports X Corp's case to the extent that it provides evidence of a misconception of a legal test or an extraneous consideration being taken into account. To the extent that the decision record merely fails to disclose the taking into account of mandatory considerations, it advances X Corp's position that only if the failure leads to an inference that the consideration was not taken into account. Such an inference can be readily drawn in the case of a statement of reasons produced in purported compliance with a provision such as Section 13 of the Act, because compliance requires an explanation of reasons and reference to the evidence relied upon. More causation is needed when reasons are given voluntarily. In effect, silences in a statement of reason are meaningful only if it appears that the statement was intended to be comprehensive. The decision record at the present case does not appear to be of that kind. The decision record indicates that some attention was given to the test proposed by Section 106.1 as to whether or not the material is Class 1 material. That test requires consideration of whether the material would be likely to receive a refused classification under the Classification Publications, Films and Computer Games Act 1995, and 9A3 of the decision record expresses itself in language taken from the relevant clause of the National Classification Code made under the Act. Neither the code nor the guidelines for the classification of films 2012 is expressly referred to, and no reasoning process is set out therein. However, given the nature of the document, it is it difficult to infer from this that there is no such reasoning process or that considerations necessary for the analysis were ignored. To the extent that these things are not said in the decision record, therefore, this does not advance X Corp's case that the notice is invalid. Further, in my conclusion above as to where the onus of proof lies on the issue is wrong, omissions from the decision record do not prevent the Commissioner from proving the delegate's reasoning process in more detail, even though that might require the courageous step of calling evidence from the decision maker. Okay, I'm going to break there for a second because holy crap, this is text heavy. Oh, and we have, sorry guys, I know that I'm ignoring chat, but there is a PSA in the pin chat that I'm just going to be reading through this because I do intend to repurpose this for like a proper video. There will be a regular show in 30 minutes or so, provided I can get through this. Did you see the budget? I didn't bother looking. Honestly, I was going to sit down and read through, but after what I saw come out of the other people's readings of it, I thought, you know what, my time can probably be better used. But Jerome Fury's been named member of the month at the gym, currently going 2 times a day, 6 days a week, 45-minute sessions. Damn. Did Hayden even get any sleep? Chicken nuggies is a reward for being good. No, we had chicken nuggies for dinner because the munchkin was good at ballet. So, okay, let's get back into this. I've only got 10 pages left, and the last page is like the signature page. So, as to positive indications of error, X Corp relies on Section 7F of the decision record, which notes that the incident shown in the stabbing video was described as an act of terrorism by the Premier of New South Wales and the New South Wales Police Commissioner. There is a strong argument that the characterization of the attack depicted in the stabbing video as an act of terrorism, and the opinions of other persons as to this characterization are irrelevant to whether the video would be classified as refused classification. This is fair. His Honour is specifically hitting on why would it matter and why is it up to this individual as to whether or not this would be classed as refused classification, and why would you take into account the Premier of New South Wales or the Police Commissioner's opinion on it when you're looking at the overall morality of society. They're two people out of a distinct demographic. Briefly, the arguments are as follows. Refused classification is the highest classification for films under the Classification Act, Section 7.2. The matters to be taken into account in a classification decision under Section 11 of the Act include the standards of morality, decency, and propriety generally accepted by reasonable adults, and the literacy, artistic, or educational merit, if any, of the publication, film, or computer game, and the general character of the publication, film, or computer game, including whether or not it has medical, legal, or scientific character. The persons or class of persons to whom or amongst whom it is published or likely to be or intended to be published. Films must be classified in accordance with the Code under the Classification Act, Section 9. Section 9A, which gives an automatic refused classification to a film that advocates a terrorist act, is not engaged by the mere depiction of such an act. Relevant to the depiction of an act of violence, Clause 3 of the Code calls for a refused classification for a film that depicts, expresses, or otherwise deals with matters of violence in such a way that they offend against the standards of morality, decency, and propriety, generally accepted by reasonable adults to the extent that they should not be classified. Which basically boils down to why we don't have snuff films, for example. The guidelines focus on what is termed an impact test. Material is to be classified as RC if the impact exceeds that of R18 material, which does not exceed high. The guidelines then add that films will be refused classification if they contain relevantly gratuitous, exploitative, or offensive depictions of violence in a very high degree of impact, or which are excessively frequent, prolonged, or detailed, or cruelty or real violence which is very detailed or which have high impact. The classification regime is thus concerned with how an act of violence is depicted and whether the depiction is likely to offend standards of morality, decency, and propriety. The language of the Classification Act, the Code, and the Guideline applies both to the fictional works and footage of real events. Material that advocates or provides instruction for terrorist acts is dealt with specifically by separate provisions. Hence, whether an act has characteristics that attracts the label of terrorism is not relevant to how a film showing the act, and only the act, would be classified. A fortiori, whether the act has been described by others as an act of terrorism is irrelevant. However, while the argument has considerable force, it does not lead to the conclusion that the delegate erred, that they made a mistake. Section 109(1) is expressed in discretionary terms, and by force of Section 33(2)(a) of the Act's Interpretation Act, is to be read as conferring a discretion as to whether or not the issue of removal notice once conditions in paragraphs A to D are satisfied. The fact that the incident shown in the stabbing video has been identified by persons in authority as a terrorist act may confer particular meaning to the video in the eyes of some viewers. It may make the video more likely to be used as a recruiting tool or a means of intimidation by terrorist groups. This is at least potentially relevant to the exercise of the discretion in Section 109(1). The decision record does not identify the particular stage of the decision-making process at which the description of the act as one of terrorism was given weight. Mere reference to the description as something that was taken into account, therefore, does not point to that matter having been erroneously considered as an aspect of the classification question. Finally, X Corp submitted that the decision to issue the notice was vitiated by jurisdictional error, that it was unreasonable. The stabbing video it was submitted was simply not capable of being seen by a reasonable person as Class 1 material. It's difficult to say much about this point without entering into the merits of the decision, which are not a matter for the court. The decision is the subject of an application for merits review with the Administrative Appeals Tribunal, where those merits can be carefully weighed with the benefit of detailed submissions and potentially expert evidence. The decision to be made under the Classifications Act, the Code, and the Guidelines is evaluative and involves identification and application of the standards of morality, decency, and propriety generally accepted by reasonable adults. These things are highly debatable. While it is certainly arguable that the depiction of violence in a stabbing video is not sufficiently long, detailed, or otherwise impactful warrant an RC classification, it does not follow that the view taken by the delegate was not open. For those reasons, I've concluded that on the evidence, it is not a substantial possibility that X Corp will be able to establish that the removal notice is invalid. And if the Commissioner bears the onus of proof of validity, there is not a sufficient reason at this stage to depart from the assumption that that onus can be met. So that was the first part of it, because X was basically going to argue that the issuing of the notice in the first place was not viable and would not stand up to scrutiny in the court once challenged. The courts basically turned around and said, well, no, we think that there is enough there that the notice itself would be legitimate, and because we have to take it at face value that it is, that's not a reason for us to turn down the injunction, which is fair and fine. You'll notice that the judge spent about 10 pages explaining exactly why he decided to refuse it on that basis. Thankfully, that's because he then jumps into the all reasonable steps, which is really the basis for why he refused to extend the injunction in the first place. The source of the dispute between the parties on this issue is that while X Corp has agreed to geo-block the 65 URLs specified in the notice so that they're not accessible to users with IP addresses in Australia, the Commissioner contends that it is not sufficient to comply with the notice. A significant number of people in Australia use virtual private networks to connect to the internet without using an IP address that is linked to an Australian provider. These users, while physically in Australia, are not affected by the geo-blocking X Corp has imposed, and therefore still have access to the 65 URLs. The Commissioner therefore seeks a final injunction that would require X Corp to remove the 65 URLs from its platform altogether or make them inaccessible to all users. They don't have the right to request that of anybody. There appears to be no dispute that because of the use of VPNs, that this is what it would take to prevent all users in Australia from going to one of the 65 URLs and viewing the stabbing video. The Commissioner argues that such an action is within the all reasonable steps that the removal notice requires to be taken. X Corp argues that a requirement for worldwide removal or blocking of the material goes well beyond what is reasonable. The policy questions underlying the parties' dispute are large. They've generated widespread and sometimes heated controversy. Apart from the questions concerning freedom of expression in Australia, there is widespread alarm at the prospect of a decision by an official of a national government restricting access to controversial material on the internet by people all over the world. It has been said that if such a capacity existed, that it might be used by a variety of regimes for a variety of purposes, not all of which would be benign. I would argue that any government restricting access would not be benign. I do not believe that that is an appropriate term for it. Benign in any worldwide censorship by any government is in no way benign. Sincerely apologies, Your Honor, but I would respectfully disagree with you on that. The task of the court, at least in this stage of the analysis, is only to determine the legal meaning and effect of the removal notice. That is done by construing its language and the language of the act under which it is issued. It is ultimately the words used by Parliament that determine how far the notice reaches. Section 109(1), which is set out above, determines what a removal notice is and does. The notice may be given to... The only notice that may be given is a notice requiring the provider to take all reasonable steps to ensure the removal of material from the service. The Commissioner chooses the material to which the notice is to be applied based on whether it is Class 1 material, but does not have a discretion concerning how stringent or widespread the restrictions on access to that material are to be. The notice necessarily requires all reasonable steps to ensure the removal of the material. Removed, as noted above, is defined in Section 12 of the Online Safety Act. Section 18A of the Acts Interpretation Acts requires, as a common sense would suggest, that other grammatical forms of the same word be given corresponding meanings. Removal of material from a social media platform is a process that results in the material being removed in the defined sense. That is, a state of affairs where the material is neither accessible to nor delivered to any end users in Australia using the service. The phrase any of the end users in Australia must be used in context. One aspect of the context is Section 23, which provides that the Online Safety Act extends to acts, omissions, and matters and things outside of Australia. Again, I would argue that the Australian government did not have jurisdiction or power to do so. A second aspect of the context is the objects of the Online Safety Act set out in Section 3, which are to promote and improve online safety for Australians. The reference to Australians suggests that the Act directs its attention to all Australian residents, not only those who use Australian service providers to connect to the internet. A third aspect of the context is the explanatory memorandum to the bill for the Online Safety Act. The explanatory memorandum does not cast any direct light on the intended scope of the removal notice under Section 109, other than by observing that the section was intended to apply whether or not the relevant service is a provider from within Australia. It notes that the provisions in what became Part 9 of the Online Safety Act were substantially a reenactment of earlier provisions in Schedule 5 and 7 to the Broadcasting Services Act, within the time frame of an urgent interlocutory decision. To the extent which I have been able to do my own research on the legislative history is limited. With the parties both represented by competent counsel, not having submitted that any part of the legislative history would assist me in resolving the constructional issues as to what the removal notice requires to be done, I proceeded on the basis that analysis of the former provisions of the BS Act would not be illuminating. The breadth of which the objects of the OS Act expressed indicates that any of the end users in Australia in Section 12 should not be read narrowly. I was not taken to anything in the Act suggesting that the location of the IP addresses through which a person physically located in Australia connects to the internet was intended to make any difference as to whether or not they were denied access to Class 1 material by operation of the removal notice. The Act does not use concepts derived from the structure of the internet in lieu of ordinary geographical or territorial notions to describe where people are. I've concluded that the phrase was intended to have its ordinary meaning and that removal therefore means making the material inaccessible to all users physically located in Australia. Boom. Therefore, by instituting geo-blocking, that is a reasonable step. The original location of the relevant provisions in the BS Act, which regulates traditional broadcast media, tends, albeit not very strongly, to confirm this conclusion. What the removal notice requires, therefore, is all reasonable steps to ensure that the 65 URLs are not accessible to any users physically in Australia. What is meant by reasonable steps is therefore critical. I have no doubt that removing the 65 URLs from its platform altogether would be a reasonable step for X to take, in the sense that a decision by X to take that step could readily be justified. There is uncontroversial evidence that this is what other social media platforms have done, and that X Corp would not be in breach of any United States law if it took this step. However, that is not the test. The Online Safety Act pursues as a policy. It is not bounded by the policies of service providers or their contractual relationships with their users. Section 109 imposes its requirement regardless of the wishes of providers and of individual users. The qualifier reasonable should therefore be understood as limiting what must be done in response to a notice to take the steps that is reasonable to expect or require a provider to undertake. The understanding is consistent with how duties arising under the general law to take reasonable steps commonly work. Identification of the steps that are reasonable in this sense may involve consideration of expense, technical difficulty, the time permitted for compliance, which may be short, given that it's like 24 hours, and other interests that are affected. It is the last of these factors that is the focus of the parties' disagreement. The argument that in making the 65 URLs inaccessible to all users of X Corp's platform everywhere in the world is not a step that is reasonable to require X Corp to perform in order to ensure the URLs are inaccessible to Australian users, and therefore is not a step required by the removal notice, is powerful. If Section 109 of the Online Safety Act provided for a notice imposing such a requirement, it would clash with what is sometimes described as the comity of nations in a fundamental matter. That concept and the principle of statutory construction that arises from it were recently discussed in reference to earlier cases in BHP Group Limited versus Impio Bardo in the High Court in 2022 by Chief Justice Kiefel. BHP Group Limited and Impio Bardo in the High Court, per the Chief Justice and Justice Gallagher. You know, I'm just going to cut that out. It is not limited to the familiar presumption against the extraterritorial operation of statutes, and is therefore not excluded here by express provision for extraterritorial operations in Section 23 of the Online Safety Act. It is useful to set out that their honour's recitation of the authorities at paragraphs 27 to 31. Exposition of the common law presumption in play in Morgan v. White and Meyer Hine can be traced in Australia to Jumbono Coal Mine, no liability versus the Victorian Coal Miners Association. There, Justice O'Connor said most statutes, if their general words were taken literally in their widest sense, would apply to the whole world, but they are always read as being prima facie restricted in their operation within territorial limits. Under the same general presumption, every statute is to be interpreted and applied as far as its language admits, as not to be inconsistent with the comity of nations or with the established rules of international law. Plainly, Justice O'Connor did not see the implied restriction on the territorial operation of a statute, to which he referred to in the first sentence as freestanding, but rather as a reflection of the general presumption which he expressed in the second sentence with reference to Maxwell on statutes. There, the presumption appeared to be, in precise terms, adopted by Justice O'Connor under the heading Presumption Against the Violation of International Law. In Barcello and the Electrolytic Zinc Co. of Australasia Limited, Justice Dixon expressed the presumption in the same language drawn from Maxwell on statutes as had been adopted by Justice O'Connor. His Honour did so interchangeably with language drawn from the 19th century English authority to that effect, that it is always to be understood and implied that the legislature of a country is not intending to deal with persons or matters over which, according to the comity of nations, the jurisdiction probably belongs to some other sovereign or state. You wouldn't think that it would need to be set out and stated in court in reasoning that it is unreasonable for a nation to expect that its laws apply in another country. Which is basically what that boils down to. That there is case law going far back as this 19th century saying that the courts have already decided that irrespective of what is put in legislation, it is not intended that federal or state legislation apply to other nations or impact on other sovereign states. Justice Dixon returned to the presumption in the Wangunai Rangidikai Electric Power Board versus the Australian Mutual Provident Society. The well-settled rule of construction, His Honour there explained, is that an enactment of describing acts, matters, or things in general words, so that if restrained by no consideration lying outside its express meaning, its intended application would be universal, is to be read as confined to what, according to the rules of international law administered or recognised in our courts, it is within the province of our law to affect or control. In the Crown v. Foster ex parte, Eastern and Australian Steam Co. Limited, Chief Justice Dixon expressed the presumption yet again. He did so more pithingly in terms which he said were appropriate to be applied to the Commonwealth Statute after the Statute of Westminster Adoption Act. He described it as a presumption which assumes that the legislature is expressing itself only within respect which internationally considered are subject to its own sovereign powers. If given the reach contended by the Commissioner, the removal notice would govern and subject to punitive considerations under Australian law the activities of a foreign corporation in the United States, where X Corp's corporate decision-making occurs, and every country where its servers are located, and it would likewise govern the relationships between that corporation and its users everywhere in the world. The Commissioner exercising her power under Section 109 would be deciding what users of social media services throughout the world were allowed to see on those services. The content to which access may be denied by a removal notice is not limited to Australian content. Insofar as the notice prevented content being available to users in other parts of the world, at least in the circumstances of the present case, it will be a clear case of national law purporting to apply to persons or matters over which, according to the Comity of Nations, the jurisdiction probably belongs to some other sovereign or state. Those persons or matters can be described as the relations of a foreign corporation with its users of its services who are outside and have no connection with Australia. What X Corp is to be permitted to show to users in a particular country is something that the Comity of Nations would ordinarily regard as the province of that country's government. The potential consequences for orderly and amicable relations between nations if a notice with the breadth contended were to be enforced are obvious. Most likely, the notice would be ignored or disparaged in other countries. And here, the parties on the application tended report by experts on US law who were in agreement that a US court would not enforce any injunction granted in this case to require X Corp to take down the 65 URLs. Yeah, a little something called the First Amendment may come into play. Section 23(2) of the Online Safety Act extends the operation to its provisions of acts, omissions, and matters and things outside of Australia. It confirms that X Corp is in breach of the removal notice if it fails to take some reasonable step, notwithstanding that the act or omission constituting that failure occurs overseas. However, Section 23(2) does not control the meaning of all reasonable steps. A clear expression of intention would be necessary to support a conclusion that Parliament intended to empower the Commissioner to issue removal notices with the effect that she contends. Basically, if Parliament had intended her to have the power to affect all things worldwide, they would have had to have said so in the legislation. As a result of that, read in context and in light of the normal principles of statutory construction, the reasonable steps required by a removal notice issued under Section 109 do not include the steps which the Commissioner seeks to compel X Corp to take in the present case. For those reasons, I've come to the view that based on the arguments advanced at this interlocutory stage, that the Commissioner will not succeed in establishing that compliance with the removal notice entails blocking access to the 65 URLs by all users of X Corp. It follows that there is not a prima facie case for the grant of a final injunction in the terms sought. Boom, mic drop. The judge has basically said, even at this stage, at an interlocutory stage, before reaching the final hearing, I do not believe that the eSafety Commissioner is going to be successful. It would be ridiculous to allow her to do so because it would impact sovereign nations. I'm removing it. The conclusion reached in the previous paragraphs makes it unnecessary to express any detailed view as to the balance of convenience. If the considerations related to the Comity of Nations had not led me to the view that the Commissioner has not made out a prima facie case, the same considerations would have led me to conclude that that the balance of convenience does not favour extending the interlocutory injunction at its current or similar form. On the one hand, the injunction, if complied with or enforced, has a literally global effect on the operations of X Corp, including operations that have no real connection with Australia or Australia's interests. The interests of millions of people unconnected with the litigation would be affected. Justifying an interlocutory order with such a broad effect would, in my view, require strong prospects of success, strong evidence of a real likelihood of harm if the order is not made, and a good reason to think that it would be effective. At least the first and third of these circumstances is largely absent. You don't say. The first is discussed above. As to the third, it is not in dispute that the stabbing video can currently be viewed on internet platforms other than X. I was informed that the video is harder to find on those platforms. The interim injunction is therefore not wholly pointless. However, removal of the stabbing video from X would not prevent people who want to see the video and have access to the internet from watching it. On the other hand, there is uncontroversial expert evidence that a court in the US, where X Corp is based, would be highly unlikely to enforce a final injunction of the kind sought by the Commissioner, and it would seem to follow that at the same time On the other hand, it is uncontroversial expert evidence that a court in the US where X Corp is based would be highly unlikely to enforce a final injunction of the kind sought by the Commissioner. And it would seem to follow that the same would be true of any interim injunction to the similar effect. This is not of itself a reason why X Corp should not be held to account, but it suggests that an injunction is not a sensible way of doing that. Courts rightly hesitate to make orders that cannot be enforced, as it has a potential to bring the administration of justice into disrepute. Basically, because X Corp is domiciled in the US, any sort of order or injunction or relief sought would need to be registered in a court in America in order for mutual recognition to apply and for it to be enforceable. What's the point of an Australian court making an order if a US court's going to laugh it out? It was suggested that an injunction, even if not enforceable, could have an educative or deterrent effect. That is not the point of an injunction. X Corp's amenability to education and deterrence might be thought to be open to doubt. That's one way of putting it. In any event, while there are sometimes important considerations in the framing of final relief, I doubt whether they have a proper role in making of interlocutory orders. X Corp also submitted that the Commissioner's failure to disclose the decision record at the initial hearing, which proceeded as if it was an ex parte application, required the interlocutory injunction to be dissolved. In oral submissions, it stressed that no allegation of deliberate concealment or anything professionally improper was being made. It also accepted that the point only affected the period between the initial grant of the injunction and the orders made 2 days later that extended it. The extension followed a further hearing at which X Corp was represented. It may theoretically be possible to dissolve the interim injunction, nunc pro tunc, only insofar as it had the effect during a particular period, but what would be the point? However, the point seems largely academic in light of the difficulties attending the enforcement of the injunction. It's not like X can go back in time and say, hey, look, for these particular 2 days when we were blocking things, we're going to undo it as if it was there. So if you were going to get likes and shares and stuff on this, we're going to attribute that to. It's not going to work. It's not going to happen. It's, as the court said, it's largely academic. It's like trying to put a Band-Aid on a broken plate that's already been glued together. In any event, while disclosure of the decision record at the first hearing might have lengthened that hearing, I'm not persuaded that it would have led to the injunction being refused. I've explained about why I do not consider the decision record points to an error in the decision to issue the removal notice. The application to extend the interlocutory injunction will be refused, and I reserve the question of costs. At the hearing on 10 May 2024, I made orders under Section 37AF of the Federal Court of Australia Act prohibiting disclosure of certain evidence. The orders were not opposed by any party. However, because orders of this kind involve a departure from the principle of open justice, the importance of which is affirmed at Section 37AE of the Federal Court Act, such orders should not go unnoticed, and some brief reasons should be given for making them. Order 1 of the orders of 10 May prohibit the disclosure of the particular URLs which contain the stabbing video and the name and contact details of the employees at the Australian Communication and Media Authority who work for the Commissioner. Disclosure of the URLs containing the stabbing video would advertise where the stabbing video can be viewed on X and facilitate access to the video by any user of the platform who is able to circumvent X Corp's geo-blocking. This would undermine what the Commissioner is seeking to achieve by bringing the proceeding and compromise the utility of the injunction that the Commissioner is seeking. I was satisfied that an order preventing disclosure of the information before the proceeding was determined was justified on the grounds set out in Section 37AG1A of the Federal Court Act, that the order is necessary to prevent prejudice to the proper administration of justice. The evidence supporting suppression of the names and details of the Commissioner's officers was contained in the affidavit affirmed by Mr. Toby Dagg, which I was satisfied it should be suppressed. Just want to quickly jump back to this. Now that he's lifted the order, there's really no need for those URLs to be suppressed. So that theoretically should be able to be released as part of the court file. That evidence persuaded me that in the heated political environment surrounding the removal order and its enforcement, disclosure of the names of individual officers could be prejudicial to their safety. Yes, I can understand how you may see it that some nut jobs would decide it'd be a good idea to go after them, given they're trying to stifle free speech. Not that that is in any way ever able to be condoned. The same can be said of the details of the communications which are recited in Mr. Dagg's affidavit. I was satisfied that the suppression of this information was justified on the grounds set out in Section 37AG1C. The order is necessary to protect the safety of any person. I was asked to make this order effective for a period of 2 years or until further order, and I agreed to make that. I agreed that that was appropriate. Order 8 of the orders made on 10 May 2024 prohibit disclosure of an annexure and exhibit to the affidavit of Mr. Michael Anderson, affirmed on 1 May 2024, and one sentence of an affidavit of Mr. Mr. Nicholas Perkins, affirmed on 8 May 2024. These parts of the evidence involve technical information about the operation of X Corp's platform and usage data, which I was satisfied was commercially sensitive and potentially useful to competitors. The order was only proposed to have the effect until the determination of the proceeding or further order, although I expect an application will in due course be made to extend its operation. I was satisfied that this order should be made under the grounds set out in Section 37AG1A. It would be undesirable if the conduct of proceedings in a court were to have the byproduct of disclosure of commercially sensitive material, or if fear of that outcome were to deter parties from presenting relevant evidence. I certify that preceding 68 numbered paragraphs are the true copy of the reasons for the judgment of the Honourable Justice Kennett. So basically, what this boils down to is that the Australian eSafety Commissioner decided to try and censor something around the world. What she just learnt was that a sitting member of the Federal Court of Australia does not believe that she has that power and decided to give her a public spanking. Now, whether or not that appears on X is a completely other matter. But the simple fact of the matter is, no sovereign government has the right to impede or affect or enact laws that apply to the citizens of other sovereign nations that have no relationship to Australia whatsoever. That is what she tried to do, and that is what the court has said no to. He has now provided significantly persuasive precedent as to why any injunction going forward of a similar nature should be dismissed, although I'm willing to bet she's going to appeal it to the full federal court. Now, I would be fully expect that the federal court would accept His Honour's reasonings for this, because it's just common sense. But anyway, as always, people, please remember, you're not a piece of shit. You have value and you do contribute to society. And please, stay so. Let me try that again. As always, people, remember, you're not a piece of shit. You have value and you do contribute to society. And as always, stay healthy, wealthy, and wise. And I'll catch you on the flip side. Doing these sorts of videos is not only a mouthful, but it's like, oh. Okay, now I can see that there's like 52 of you. Holy shit, people, I'm not actually going anywhere. That was just me ending the clip. Oh, fuck. I was gonna go back and go through chat and say hi. Dear good man, you're getting better at reading huge amounts of text nonstop. Yeah, just I don't know. My mouth still gets dry when I'm doing like long readings like that, and if it's something that I haven't specifically read through, Shia LaBeouf clapping noises. Thank you. Common sense is not common. It's rare. It's practically a superpower. Tell me about it. Look, the simple fact of the matter is that this chick had an axe to grind with Twitter, with Elon, with X Corp as a whole now, and she's doing her best to try and override the United States Constitution by using the powers of another country. Emphasis on country. So, I mean, how did she really think this was going to go? The simple fact of the matter is that, and getting paid to do it at the same time. No, what's worse, Chris, is getting paid taxpayer money at the same time. Oh, damn it. I'm going to have to put an extra bit in, and then I'm going to have to edit it out because I completely forgot. Hang on. Okay, so now let's have a look at the statement put out by the eSafety Commissioner. Statement on the federal court decision. This is how you know she understood that she got spanked. She kept it short, sweet, and still didn't take any responsibility for her actions. The federal court today did not grant the eSafety Commissioner's application to extend the interim injunction requiring X Corp to hide the material identified in the removal notice given to X Corp on April 16, 2024. The removal notice required X Corp to take all reasonable steps to ensure the removal of violent material of the alleged terrorist act at Wakeley in Sydney on 15 April 2024. The interim injunction previously ordered by the court would have expired at 5 p.m. on 10 May, but during the hearing on Friday was extended to 5 p.m. today. The matter will return to court for a case management hearing on Wednesday, 15 May at 9:30 a.m. The removal notice identified and required removal of material from specific URLs, formerly on X, formerly Twitter, where the material was located, but did not extend to commentary, public debate, or other posts about the event. Notice how they tried to backtrack and say that they did not extend to commentary, public debate, or other posts about the event. More to the point, it identified and required removal of material from very specific URLs. 65 URLs was not going to prevent this in any way, shape, or form. She was effectively going to try and force X to go on a whack-a-mole hunt to try and remove this video from all access across the internet. Now, we know for one thing, once something's on the internet, it's out there forever. It is not possible to hunt down every copy of that video, whether it be on X, Facebook, other Instagram, other social media. It will still continue to exist. This was purely a hit job on X because she had an axe to grind and she didn't like being told no. Okay, and I think quick cutting it back there, I should be able to slice it and split that in and whatever else. Wonder if she's a country music fan. Maybe. Is this something that can get her removed from a job? No, probably not. Making Australia look like a joke on the world stage? Maybe. Well, look, Chris, the trouble is she's appointed. And at the moment, the person making Australia look like the biggest bunch of douches on the world stage is her boss. And he doesn't really care because he doesn't want to be memed. So he's happy if they try and enact that. So I fully expect that she's just going to keep going at them. But the simple fact of the matter is this judgment is a massive fuck you to the eSafety Commissioner by the federal court, saying you do not have the powers to do this. No one does. It is a reasonable step to make sure that Australians cannot access it by geo-blocking it. Effectively, what they're saying is that if you have an issue with people using VPNs to access stuff from outside Australia, you need to legislate and remove VPNs, which there's no way in hell they'll ever get away with. It's literally a case of the cat's out of the bag. So why bother? Why try? All you're doing is being an ass, wasting taxpayer money. Actually, I tell you what, I'll bring up Craig Kelly's text on it. Hang on. Because he was ropeable, as one would expect. That's the stuff about the budget. Here we go. If the eSafety Commissioner doesn't resign, she must be sacked. After the scathing decision handed down by the federal court and just published that her demand that X censor the internet everywhere in the world was not reasonable, the eSafety Commissioner must resign or be sacked. To turn up to the Federal Court of Australia using taxpayer money to fund a legal case arguing that the eSafety Commissioner had the power to censor the internet everywhere in the world was an absurdity. It made in Australia an international laughingstock. The eSafety Commissioner has demonstrated that she is power drunk, has delusions of grandeur, and has acted in a manner of a disgruntled employee carrying out a vendetta against her previous employer. She's demonstrated that she's completely unfit for the job, and if she doesn't resign by the end of business, Albanese must sack her. Yeah, well, that sure as shit didn't happen. Because she more or less stood up and said, we'll cop it on the chin and apply, we'll appeal it. Well, good luck with that. Because I'm sorry, but His Honor made some pretty scathing remarks about whether or not you had the power to do that. And this is Justice Kennett, one of the justices of the federal court, who generally hears appellate matters anyway. You really think that him having to punt this one up to the full federal court to a bench of 3 judges is going to rule in your favor? You honestly think that 3 of the greatest legal minds in Australia are going to sit there and go, yes, we think that the federal government has the right to make laws that apply to people not in our country? You're a freaking moron. Why you thought this was even remotely applicable is beyond me. Anyway, I wanted to get that one pre-recorded and get that sorted, so thanks, peeps. I'm already 10 minutes into my usual slot. Just text my property manager so when he views the cameras and wants to know why the police were in the lobby at 12:30 last night, at least he'll know. Because she's American, we try to control everything. Even if you could remove it from the internet, there's lots of people out there that saved it and will just repost it. Yeah, exactly. It's literally, once something's out there, it's out there. The cat is out of the bag. There's no stuffing it back in. That horse is bolted. And if you don't like something being posted on the internet, unfortunately, move to Yemen. I don't know. Where is somewhere on Earth? Oh, move to Antarctica, okay? Because the internet is everywhere. Access to information is everywhere. The fact that you still think you can be a nanny state and try and influence what people can and can't see, read, view, hear, have opinions on is pathetic. The more you push to censor it, the more it'll be seen. Yep. Oh. Not understanding that is a demonstrable reason for someone to not hold the position of eSafety Commish. I agree with you on that, Chris. So another low-level bureaucrat that thinks that they're in charge of the world. Yep. Pretty much. She's also someone who is involved with the WEF as well. Like they've got a full profile on her on the website. So we go goofy, think that the bus video I sent you is all real or fake. Tell you what, let me end this one. I'll move over to the actual show, and then we can just stuff around and chat and stuff, okay? The longer I do this, the more it's going to take me for to download it and process and all that sort of stuff. So, hang on, where are we? I won't bother using Streamlabs because that'll just take too long to set up. Oh, I don't have a Rumble stream set up. Oops. Guess that's what happens when I don't pay attention. Oh, my head. All right, there we go. Don't know why I thought it would take me longer to go through that. But thank you to everyone that just sat and listened to me like with verbal diarrhea. I appreciate that. Okay. eSafety Commissioner, customization, redirect. All right, there we go. All right, redirect's on. So once I end this, we'll don't send a loathsome Karen to Antarctica. The hell did that continent do to you, Aussie? Send her to the Middle East where they respect a woman's opinion and allow her to be the best she can be.